May it please your lordship. With due regard to the concern the other side, a vaccination item 8 and 9 your lordship. I seek the accommodation for today your lordship.
You are for?
I am for the petitioners your lordship. In both the items.
Who is the other side?
Mr. Rajiv Purpudari appears assisting Mr. Learned Advocate General your lordship. We have taken the
Mr. A. Das, learned counsel for the petitioner seeks adjournment of hearing of these separate orders in this case, citing personal difficulty of the arguing counsel.
Yes, Mr. Senior Counsel came sorry, out of station your lordship.
Stop. The prayer is not opposed by Mr. R. Bopadari, learned standing counsel for the finance department.
Revenue.
Some appearing on behalf of the respondents. In view of the above, hearing of this matter stands adjourned for 2 weeks. Same order in the other matter.
Interim
It
orders.
is a common order. Common order.
There are interim orders your lordship. Both the petition.
Interim order operating in this case shall stand
Much obliged your lordship.
extended till the next listing.
Obliged your lordship.
May it please, my lord. Prayer for listing of a motion matter for tomorrow. My lord, the urgency in this case is that I am a helper working in the Anganwadi center. For the last 8 years, I have been rendering my valuable services. Now, my lord, they've advertised for that post, my lord. Tomorrow is the date of advertisement. Third-party rights will be created, my lord.
Why don't you have it on Friday?
My lord, tomorrow, my lord, is the date for advertisement, my lord. Tomorrow, people, other candidates, they will put their applications now, my lord. Third-party rights would be created, my lord. Then,
Friday. You are not correct.
Huh?
Friday.
well, my lord, tomorrow is the last date, my lord.
Last date for what?
Tomorrow is the last date for giving all the applications, my lord. So other candidates will also come into the picture.
Friday. Your understanding of law
My-
is not correct. Yes.
Lordship,
It doesn't create third party right like this. But Friday will take up your matter.
My-
Friday,
my-
give the Friday.
I pray for listing a matter for admission, Lordship. This matter was listed.
You have to now go to the register.
I went to the registry, Lordship.
When did
but
you go?
Before Holly, Lordship.
You do it. Since last week there is a system in place.
Lordship.
You go in. There is a register now. They are maintaining a proceeding.
Lordship.
All requests will have to be listed. We are inspecting the files regularly, registers.
I hope so, Lordship, because
When the
Since-
judge is saying it is the case, what do you mean by I hope so? Go and do it there. Yes.
May I please, your lordship, I'm praying for listing of a writ petition tomorrow, your lordship. We had filed it yesterday. The urgency in this matter is that the ministerial staff of the Labour Commission who are eligible, their promotions have been held up.
Monday, next Monday.
Lordship, there is a bit difficulty on.
Rejected. There is no urgency in promotion matters. Yes.
I pray for listing of an IA, my lord, for implement of parties. My lord, I have filed this application on 20 February, my lord. Till this case has not been registered.
IA in what? Writ petition. What is the urgency?
Urgency, my lord, for implement of parties. But my lord, I have filed
So
it.
you see, these mentions are to be used when there is real urgency.
Yes, my lord, absolutely.
Because the judges are not making lists. List is created by the
But
registrar.
my lord, this case already, my lord, 20 February, I have filed this application. All objections are cleared, my lord. Till today, they have not registered, my lord.
You put it before the register, he will get it listed.
Yes, my lord.
Yes.
2 weeks time लगेगा director to time decide. Lordship, in this matter, I am seeking 2 weeks accommodation, Lordship. We have the government has written to the director, Lordship, but 2 weeks time may be granted for us to.
Then we'll issue notice and fix it immediately after being vacation.
We have already served him coffee.
Yes.
All right. But Mr. Bididas Lana Senior, assisted by Mr. J. Lothal and counsel for the writ petitioner. Also had Mr. A. Chalia, learned standing counsel. This is which department? Health department.
Health department.
Health department, Assam, who submits that instructions have already been called for as per the order dated 10/3/2025 passed by the. But some more time will be required to place the same on record. In view of the above and considering the nature of grievance expressed by the writ petitioner, this court is of the view that the matter will require further consideration. As such, issue notice of motion returnable on 23rd of April 2025. Since Mr. Cholia has appeared and accepted notice for
All the
all
respondents.
the respondents, no formal notice is required to be served in this case. They send in this case, extra copy of the writ petition from a requisite in numbers be furnished to the learned departmental council if not already done. I list this case again for admission hearing on 23rd April 2025 as a fixed item. Should I mention that pendency will not be a bar to consider this case?
Yes, please.
It is, however, made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the writ petitioner in accordance with law if so advised.
Wait, your lordship.
Yes,
Lordship, I have filed the additional affidavit, lordship, and I have enclosed the appointment letter, joining letters also, lordship.
so what is your case?
Lordship, initially I was appointed in the Sakhi one-stop center by an NGO. After the appointment letters had been.
Your appointment was by an NGO.
Yes, lordship.
Where is the appointment letter?
Lordship would find, it starts from page number 75 of the additional affidavit.
Hmm.
So all the petitioners, they have different, this appointment letters. And then these are joining letters. It starts from page number 75, it goes on to page number 98.
So,
So my lord, from
so it clearly says that with 60 days notice, you can be terminated. It's purely temporary.
I'm coming to all this, lordship. From that, I have been continuing from 2019 till present.
Hmm.
Now, I was continuing on a guideline which was of 2017. Now, lordship, the NGO had the power to recruit me.
To?
To recruit me.
Hmm.
In the year 2022, the 2017 guideline was replaced by 2022 guidelines of Mission Shakti. Under that guideline, there was one clause that the department may integrate all these NGOs into the different government agencies if the government agencies wants. Now, on the basis of that, everything had to be done within 31st March 2024. Lordship, may kindly take up my writ petition once for a moment, Lordship.
Yes.
Now, Lordship, because of that, Lordship, the director of the Women and Child Development, he has given a guideline. That guideline, Lordship, would find at page number 67. Annexure 9. Now, according to this guideline, Lordship
Yes.
may kindly turn to page number 68D. Selection for employees for the post of multi-purpose worker security guard should be completed within 31st March 2024. The selection committee has already been constituted and sent your email, your end by letter dated so and so. And for such position, selection would be conducted by the Directorate of WCD Assam. Now, next clause. Advertisement to be published in website the www.womenandchild.assam.gov.in for positions as of OSC in this 35 districts. Districts whose do not follow the selection process as per mission guideline 22-23, taking into consideration the requisite qualification experiences. Now, this was the guideline. After that, Lordship, the director has issued a advertisement for all 35 districts. Lordship would
Where is
find-
the advertisement?
Yes, Lordship. That is, Lordship would find. I'm coming to that, Lordship. It is at page number 55, Lordship. Now, this was for, again, there was a advertisement. Subsequently, after that, this advertisement was cancelled.
No, which is the current advertisement?
Lordship, I'm coming to that.
Please come to that first,
Lordship.
then you will go wherever you want to.
Lordship. Lordship, the current advertisement is at page number 64, Lordship. and it has been issued by the Deputy Commissioner Borpeta, who do not have any jurisdiction under the Mission Shakti guidelines. This advertisement has been published only for the district of Borpeta, and all these posts has been given in the advertisement. And all these posts are not vacant. The petitioners are in the post, Lordship. Now, an advertisement cannot be made of a post which is not vacant. Suppose I am wrongly, whatever may be the conditions, I have to be served with a legal, with a so-called notice. If my employment is bad in law, he may remove me, and then he may give an advertisement.
That's right. So they will not remove you without serving 2 months notice. That will clarify.
No, but then, Lordship, but this, Lordship, prima facie, without there being a vacancy, can there be any advertisement, Lordship? That is my one leg of argument.
Show me the law on that.
Lordship, I'm coming to that, Lordship.
You are only coming to everything that the court asks.
Yes, Lordship. Lordship,
Which is the judgment you are referring to?
Lordship, this is a recently passed, Lordship. By the Supreme Court, Lordship, in the year 2025, Lordship. In paragraph number
See,
22.
Mr. Deka, the case you have argued,
Lordship.
it is a good case for dismissal. But you had only one point which you did not argue. On that ground, we'll examine it. The only important point which you had, you have completely ignored that. That's the problem.
Lordship.
Because you start thinking like the client, not like the lawyer. That is the problem in this system today. Most of the young counsel like you, they start clamoring like clients in the court rather than presenting their case. Yes, Mr. Chutia, this is again a case of temporary contractual post.
Yes,
You can't
contractual post.
replace one contractual by another.
No, now it is a permanent advertisement for permanently. The selection committee is constituted and the ADC also.
No. See the advertisement at page 64. Please
64.
read the first 3 lines.
Applications are invited from the eligible candidates who are citizens of India and fulfill the criteria for education, qualification, experience, so and so below against the category of purely temporary contractual post of one stop under so and so district, and having a requisite qualification and experience may submit the application mentioning so and so district room number so and so.
Yes, that's enough. So it is again for contractual.
Yes, Lordship.
You
It
please take your seat. You did not argue the point which was in your favor. Now you don't have to say yes or no. Take your seat. So how can you replace one contractual by another
Another cannot
without
be.
terminating the contract agreement?
But it is a contextual. It is not a.
So you have to terminate it by following the procedure laid down. In the
But at this stage, we don't have this instruction whether terminated or not, my lord. On the history of the petitioner, he is saying, my lord. So far, my lord, this question is, my lord, the contextual and my lord, temporary basis, the contextual and other ad hoc. Ad hoc is defined, my lord, and contextual is defined. Contract is for a purpose of a contract.
That's
But
correct. So
ad hoc-
has his service been terminated?
Ad hoc may be appointed against a sanctuary post also, my lord. That maybe cannot be replaced by another ad hoc. That is true, my lord. So this case is a contract basis. And now ADC's power has been given by selection committee.
No. Even you are missing out. See, you have engaged someone on contract basis. He is working. You issue an advertisement to appoint another person on contract basis
On
on the
contract
same
basis.
post.
Right, I understood, madam.
You, unless you terminate the previous contract by
Yes.
following the due process, you can't do it.
Yes, that
That's
is
the
true.
only case he had. He
Yes,
did
yes,
not,
this is the only case, my lord.
he did not project.
So at this, my lord, this point, my lord, I will have to clear. Let the next week, my lord, I will obtain instruction.
No, we'll give you 4 weeks time to obtain instruction, but you can't terminate him. If he's continuing in service as on date, he will not be disturbed.
It has not only been terminated.
Yes, rest to go ahead with the process,
Yes,
which will be subject to further order.
rest should be, my lord, to continue. Due to pursuant to advertisement, they will.
That
start
will go on. We are not interfering.
Only her post,
It's
Eight
a
petitions.
lady,
lady.
how many of them?
8, Lordship.
They will not be terminated.
And one more petition I have filed, Lordship.
Yes, but the maintainability will be open because
Yes,
8 of
but-
them have come.
Yes,
So maybe the writ petition will be dismissed ultimately. That question you can raise. These are individual cause of actions.
yes, my lord.
Lordship, I have mentioned this, Lordship, with the case law in paragraph number 8.
All right,
24.
if they take that plea, we'll consider, and if that is the correct law, it will be dismissed.
Lordship.
Take down, heard Mr. P. Decker, learned counsel appearing for the writ petitioners. Also heard Mr. T.C. Chutia, learned additional senior government advocate appearing on behalf of respond numbers. You have for respond numbers?
I am for 2, 3, 4, 5, and 6.
Phone numbers 2, 3,
Central government for 1.
4. Why not 1? Achha,
One central government, my lord.
2, 3,
usually
4,
first
5, 2 to 6. Miss, your name, please? MK? Acha, you are the CGC? Then we'll record his name. Mr. G. Pegul, CGC has appeared on behalf of the respond number 1. Full stop. The 8 writ petitioners herein were engaged in the one-stop centers under Mission Shakti on contractual basis way back in the year 2019. And since then, according to the petitioners, they are continuing to render their services. Full stop. However, in the wake of the advertisement notice, they are all from Borpeta, these 8 petitioners.
Borpeta.
In the wake of the advertisement notice dated four 3/2025 issued by the District Commissioner Borpeta, that is the respondent number 4 herein. The petitioners have approached this court by filing the instant writ petition, apprehending that by issuing the impugned advertisement notice, the respondents are seeking to replace the writ petitioners by engaging fresh one-stop, fresh Sakhi. Is it called, what is it called? Sakhi?
Sakhi One Stop Center. Sakhi,
Fresh
S-A-K-H-I.
Sakhi one-stop center on contractual basis. Hence this writ petition. Full stop. By referring to the appointment letter issued to the writ petitioners, individual appointment letters issued to the writ petitioner. The petitioner's counsel submits that the authorities cannot terminate the service of the petitioners. No, submits that the petitioners are continuing to operate as one-stop Sakhi center even till today. And as per the terms and condition of the contract agreement, their services cannot be, the contract cannot be terminated without giving 60 days prior notice to the petitioners, which has not been done in this case. First of, it is also the submission of Mr. Decker that one set of contractual employees cannot be, one set of, this is called contractual employee, is it?
Yes, Lordship. Temporary employee, Lordship.
Huh?
Temporary employee.
One set of temporary stroke contractual employee cannot be replaced by another without terminating the earlier contract. On such ground, Mr. Decker has paid for an interim order of protection. Mr. T.C. Chutia, learned senior government advocate Assam, prays for some time to obtain instruction. The learned government advocate Assam has, however, opposed the prayer for interim relief by submitting that the process need not be, the entire appointment process need not be stalled at this stage. After hearing submissions of learned counsel for both the sides, this court is of the opinion that the matter would call for further scrutiny. As such, issue notice of motion returnable on 5th of May 2025, Since the respondents are already represented, no further notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that the respondent number 4 may go ahead with the appointment process as per the advertisement notice dated 4/3/2025, if so advised. However, the appointment of the writ petitioners shall not be disturbed in any manner without serving them prior 60 days notice as per the contract, as per the terms of the contract, if they are still operating as one-stop Sakhi center.
Sakhi one-stop center.
Sakhi one-stop center in the district of Barpeta.
Lordship, there's another writ petition, Lordship. I have filed, it has not come, Lordship.
So what do you want? In order to be
No,
passed in there?
no, Lordship.
My lord,
No, if you want, then
No,
we
no.
can pass.
my lord, petitioner, he has not, my lord, annexed the appointment letter, and he will provide it, my lord.
No,
Appointment.
in the additional affidavit, they have brought it.
Additional affidavit, I don't have the additional affidavit.
Oh, they've
Did
not
you-
given you.
It has been served, Lordship, yesterday.
In the additional affidavit, the appointment letters are there. The
I will check.
terms and condition of contract.
Yes, I will check it. Extra copy.
You can go ahead with the process.
Yes, yes,
But don't disturb them without serving 2
Yes,
months,
yes.
60 days notice.
you provide extra copy, no?
I'll,
May I please, your lordship?
Hmm.
The petitioner was hired, lordship may kindly come to page number 17, madam.
Sorry?
Page number 17, annexure 1.
Yes.
But we were in paper publication on 31st March 2018. He was appointed as technical expert fishery for a period of 8 years. But before completing 8 years, madam, he was the 8 years. Not 8 years.
8 years.
And after that, madam, after a proper selection procedure, madam, he was appointed, madam. The lordship will find at page number 18, his number, madam, name, and serial number 9, Abu Subham. And lordship may come to page number 20, madam, where his experience employment, madam, certificate has been given, that he has been working,
His
Since-
recruitment is made under which under which rule?
present one.
Yes.
But this has been addressed by the APSC, madam,
It is made under, the recruitment is made under which rule?
the previous one, madam.
The recruitment of fishery development officer, which is conducted by APSC, is made under which rule?
Madam, lordship may kindly come to annexure 4, madam, page 21. It's a regular appointment, madam.
Which rule?
A rule I have not seen, madam.
Then you cannot argue this matter. Because the next question I'll ask, you will say, let it be listed next week. You are asking for relaxation of age.
Yes, madam.
That is not possible unless there is a provision in the rule. Is there a provision in the rule?
I'll show, madam.
Huh?
I'll show a lordship, madam.
Where?
Madam. But earlier, madam, there was an, madam,
Voted earlier. Now, the rule that is applicable here, is there a provision for relaxation of?
No, madam.
appraisal? Huh?
No, madam.
You're sure?
Yes, madam.
Then you can't get any relief here.
Madam, let me plead my case, madam.
Yes.
What? Sometime, madam. Madam, now the age has been fixed at 38 years as on, madam, 1/1/2025, madam. So, madam, since I was working as a fishery expert for since 2018, suddenly, madam, my appointment was closed, madam. That your lordship will and madam, annexure 8, madam, is 38, madam. This has been discontinued, madam. And madam,
Page 38.
38, madam.
Yes.
This has been discontinued. I have not been terminated, madam.
Your service has been terminated.
Not terminated, but this has been discontinued. they have written a closure of the contractual agreement, not terminated, my lord.
So that means you are no longer in
No
employment.
longer in the, my lord.
So what is the relief you are seeking?
Relief is to, my lord, to relax the upper age limit, my lord.
That's what I'm telling you. You said, let me place my case. You place your case. There is nothing to be placed here.
But earlier there was a,
Take your time, but this is not going to lead you anywhere. The point here is this. If there is a provision in the rule, we'll ask them to consider. If there is no provision, the court cannot do it. That's the law. You can plead your case for half the day.
no, my
It's
lord,
not gonna make
that's
any
all
difference.
5 minutes, my lord.
Yes.
But earlier there was a, my lord, advertisement, my lord, where the upper age limit was shown as 43 years. Now, my lord, as of my lord, 2025, my age is 42 years, 5 months, my lord. Lordship may kindly come to page number 39, my lord. Annexure.
What is that what is your submission? Please tell, what is that you want?
I want to participate in the recruitment
You
process.
cannot do it because you are overaged.
Yes, ma'am. Yes,
Then
ma'am.
If you are overaged, how can you do it? You missed the bus for what? Unfortunate.
Yeah.
But then it has happened.
Yeah.
If there is a rule which permits relaxation, we'll ask them to consider.
Madam,
There is no rule, nothing can be done here.
there's a judgment, madam, from the Supreme Court, madam. And Lordship may come to the last page, madam. Earlier, there was a madam, OM of the government of Assam, madam, where madam, the age of upper age limit has been relaxed for 5 years. But that madam, that was for a period of 2 years only, madam. Lordship may come to the last page, madam.
Yes.
A decision to the
Yes.
madam. But this is the madam OM, madam, of the Personal Department, madam. But the
But this is of 2016.
16 years, madam. But this
5 years is gone already.
yes, madam. This was for a period of only madam, 2 years from the date of publication.
Yes. So, yes, say whatever else you want to say.
But this is a judgment of the Supreme Court, madam. Lordship may kindly go through it, madam.
No, what is the point?
Point is that if sanctioned posts are vacant, the state will take immediate step for filling up those posts by a regular process of selection. But when regular recruitment is undertaken, the respondent in so and those in the so and so similarly situated will be allowed to compete, waiving the age restriction.
That order, you have to get it from Supreme Court. You can't pass that order.
But I just want the upper age limit should be condemned, and my application is also pending. Madam. They have not acted upon, madam. I filed my application, madam. Is also pending, madam.
Yes.
My page number 29, madam.
Page number?
29. The Fishery Department has forwarded the representation to the Personnel Department, but madam, the Personnel Department has not acted upon, madam.
Yes.
But this is pending, madam. We have not acted upon, madam. But this is pending before the Personnel Department. Fishery Department has forwarded this application to my knowledge, madam. To the
All right.
and Lordship may kindly, madam, go through this judgment also, madam. My pleasure, madam. But the last paragraph, madam. 24. Assam Fishery? Assam?
Yeah, that's why I said you have to go to Supreme Court. They have made it clear. It is, this order is under 142. 142 power is not available with the High Court. So I said it, that you have to go to
I'll leave it
Supreme
to
Court
Allah.
for this order.
I'll leave it to
High
Allah.
Court cannot, there is nothing to leave.
This is.
High Court cannot give a direction to act in this matter unless there is a provision in the rule which permits relaxation. High Court can only say, consider his prayer.
Yes, no.
But there is no rule, you are saying there is no.
No, rule is there, madam. My senior say, madam.
Oh, you are the petitioner, you have to say which
But-
provision.
I think, madam, Assam Fishery and
Oh,
Agriculture.
you think, then keep thinking.
Maybe, madam. Lot me ask
This
this.
is really unfortunate. This is the way you are arguing in a High Court. Yes,
Lordship, in the OM Lordship, it is clearly stated that there is no chance of procedural recruitment or any relaxation of educational or any other qualification of service conditions such as year, age of recruitment, etc.
all
Lord.
right, take your seat. Yes, Mr.
Well, PSC, my lord, advertisement and for the government, my lord, government, that advertisement, I publish it, my lord. So far, my lord, the point which was required by him, my lord, there's a rule, my lord. The rule Assam Fishery and Aqua Service Rule to
Is
2020.
there any provision for relaxation of
There
age?
is a overall relaxation is there, but not as specifically mentioned in section 25. No
Where
mention.
is that rule?
Rule, my lord, probably is.
Huh? Give me your mobile.
Sorry, my lord. Actually, there is.
On the prayer of Mr. F.P. Das, learned counsel for the petitioner, let this matter be listed again on Friday.
Yes,
Yes, yeah,
But in rule mentioned that the age is 38 years.
We'll see. Let this-
The overall election period is there. That can, government can done, my lord.
So as to enable him to examine the relevant provisions of the rules pertaining to relaxation and address the court.
My lord. Leave him.
Lordship, here in this case, Lordship, I have to file the affidavit, Lordship. Can fix the matter after 2 weeks, Lordship. Any date, Lordship, I will file, Lordship. My lord,
What is the matter about?
Petitioner before your lordship is open heart surgery along with my lord having cancer, man.
Hmm.
He got retired. And very difficult to spend his day, my lord. Only GPF was given to him after retirement. Nothing has been given. And his
So
case,
why is pension has been withheld? What is the reason?
Lordship, that's why, Lordship, I have to seek the instruction, Lordship.
From whom?
Lordship, the department, Lordship.
Seek it. We'll give you half an hour.
Lordship.
Someone is a pension case patient.
Lordship,
And
I
is
do
in
it.
dire need of money.
2
His
days
pension-
required, Lordship.
Huh?
2 days, Lordship. 2 days.
days is
Lordship.
too much.
At least 2 days.
On Tuesday, we are fixing it as
Lordship.
the first item. If
Lordship.
you don't get the instruction at
I
2
I
o'clock,
will
ensure
apprise, Lordship.
that the chief secretary is present here.
I will apprise.
Cannot play around with people's life like
No,
this.
I will.
Mr. Jay Borbuel, Learned Counsel for the petitioner is present. On the request of Mr. J.K. Goswami, Learned Counsel for the state. List this case again on Tuesday next. What is the date? 1/4/2025. As a fixed item for admission, is it?
Lordship.
Is it admission?
Lordship.
So as to give one final opportunity to the learned government advocate Assam to produce written instruction
Lordship.
and apprise this court as to why the pension of the petitioner has not been released till today. The matter assumes great significance in the backdrop of the plea that the petitioner is a cancer patient and is in dire need of money for his medical treatment. Mr. D. Bhattacharya, learned standing counsel for the office of AG Assam, is present on behalf of respondent number
5.
4 or 5?
5.
5.
Lordship,
But please tell them that some harsh order is coming.
Lordship, I will.
You better release some amount.
Lordship, I will talk to the department, Lordship.
Lordship, this matters relates
Hmm.
to a disciplinary proceeding in item number 3, Lordship. I was required to file my affidavit, Lordship. My signed affidavit has not yet come. I have forwarded it. Lordship will give me some time to file my affidavit in item number 3.
Item number 3 is which case?
Ram Narayan Chaudhary.
These are both connected.
Yes,
Both are connected.
both arise out of the same
Memorandum.
Lordship.
And Lordship, there is a stay, Lordship.
Sorry?
Lordship, there is a stay order.
Huh.
And in spite of the stay order, Lordship, they have proceeded with a disciplinary proceeding, Lordship.
File a contempt case.
Contempt.
Yes. It is a 2025 matter. He wants time to file affidavit.
Yes,
We have to give
Lordship.
him.
And in item number 4, Lordship, I may be allowed to file our affidavit in reply.
Right. Heard Ms. P. Borwal, learned counsel for the writ petitioner in both these writ petitions. Also heard Mr. R.K. D. Chaudhary, learned DSGI, appearing for the respondents, who submits that although counter affidavit has already been filed on behalf of the respondents in item 4, another 3 weeks' time is required to file the counter in item 3. On such ground, Mr. Chaudhary has paid for posting these matters again after 4 weeks. Ms. P. Borwa, learned counsel for the writ petitioner, has submitted that she be given some time to file rejoinder in respect of the counter affidavit filed in item number 4. In view of the above, let these matters be listed again in the second week of May 2025 as fixed items, so as to enable the parties to exchange pleadings. Interim order passed earlier to continue. So which order is under challenge here?
Not page 42.
Page
42.
42.
45, sorry. Pair number 4, Sanjana Medhi.
Page 45.
Sanjana Medhi from Bokulani to Pare Hydropower Station, Doimuk.
Number 4, is it?
Yes.
So when was she posted in Bokuloni?
Long back, my lord.
Long back.
2000.
2000?
7. Sorry, I know.
All right. So it is not a case of frequent transfer.
Not a frequent.
Then what is
Only
the ground?
Ground that is spouse posting, my lord.
Spouse posting.
My lord.
Can the spouse be posted in Doimuk?
No, the spouse is not working with us.
Achha.
No. He is in Oil India.
Oh. Then what can be done?
My lord, one office memorandum issued by DOPT, Lordship page 30. Here it is clearly stated that that the husband and wife may invariably be posted together in order to enable them to lead a normal family life to look after
Page number?
Page number 30.
First para, last
Page number 38.
30. DOPT Office OM dated 1997, 12 June. Some criteria is given that if these signs are below 10 years, they should be invariably posted together. Here her husband is posted Dulias and Oil India, and they are having sale of 6 years and 11 years now. 6 and 11. 11 years and 6 years. Both girl is child. For studying at DPS Duliazan. And transfer policy is also there, my lord. In my affidavit reply, I have stated the transfer policy. It is also violation of transfer policy also.
Yes.
And transfer policy, page 114 of my affidavit reply. Para 11.3. Employee and her family suffering from special disease, as defined in NAPCO medical attendance rules, shall be deployed at any location of their choice or nearest to location where facilities of treatment special disease are available. This is the medical attendance call.
You're reading from which page? Page?
Page 114 of affidavit reply.
114 is not telling. What is the internal page? Running page is not telling.
NAPCO transfer policy.
What is the internal page?
5 of 19. 5 of 9.
9.
Transfer policy.
Transfer policy.
In page number 114, the transfer policy is not there. It is a part of a Supreme Court judgment. Pratibha Rani and others. Give it.
114 judgment, I have quoted 103. Oh. কি লাগিলা এইটো তেনেকে লিখে নেকি ক'ত দিলা এদিকে sorry 121 এইটো চাব লাগে টেলিকৰণ sorry man.
Yes. Which para you want to show?
11.3.
No, but disease, she's suffering from diabetes and
Diabetes,
hypertension.
that is a
These are
special
not
disease.
special. Huh?
As per their own manual, it is a special disease.
Where is it? Where is that manual?
Earlier that. Next page. I am a previous page, my lord. 30 and treatment for special disease. A medical. Sorry, my
Second
promotion.
Puntu color. The peach color is clause 30. Second,
You are referring to clause
30,
30.
30. That's right. Yes. The cost of anti-diabetic drugs, including insulin and research, shall be raised based on the advice of the AMA, authorized medical associate.
And in the, on the page 30 in the DOPT guideline, where does it mention that it should be in the same department?
Page 31, Your Lordship.
central staffing scheme.
Yes. Yes. Clause 4.
Clause 4. Lordship, if permits me,
And
clause 2 also.
No,
And-
just a minute. Let him finish.
Yes.
Your Lordship, my other submission is that DOPT guidelines per se is not applicable to us, being not a statutory company. We have our own transfer policy.
Hmm.
And we have also taken this into account and we have formulated but this is subject to organizational requirement. Even here, everywhere it is say, if para 2 may be seen also of pasted, if no administrative problems are expected to result as a consequence. So it's a question of balancing the need. Page 2, bottom line.
Page?
Page 30, bottom line, para 2.
Hmm.
So it will be a question of balancing the thing. That's
Para 2 of the DOPT letter.
Hmm.
The government, after considering the matter, has decided to accept this recommendation of the 5th Central Pay Commission. Accordingly, it stated that all minister departments should strictly adhere the guideline laid down so and so, while deciding on request of posting husband wife at the side. So it ensures that such posting invariably done, especially till their children are 10 years. If posts at appropriate level exists in the organization and same situation, if no administrative problem accepted to result as a project. As per my instruction, there in Doimuk, 2 officers are there in personnel department, 2 senior officers.
no, junior. It will be the only DG. That's my instruction.
And is there any scope to slightly modify the order, maybe not in same place, but
Your Lordship, nearby to that,
Hmm.
there is no, Your Lordship may just take once the transfer policy, Your Lordship.
no, we'll come to the policy later.
Why am I saying it? There are 2 zones. One is a soft zone and where it's a hard zone. Now, the place that she has been posted is a soft zone. Sorry, where she was being was a soft zone. From there, there's no, the nearest place is this, Your Lordship. If she wants to go to Delhi or other places, then she might, but the nearest is this only. If Your Lordship just see pace, transfer policy, whatever. There are places in West Bengal, Tripura, Delhi,
Guwahati.
Tezpur, Guwahati. Guwahati is further down.
No, forget the medical, the children are normally required to stay with their mother. And in Doimuk, the educational facilities will not be there.
No, there are now, because from Doimuk to Itananga or anything, Kendra Vidyalaya and everything will be there.
And what about accommodation?
Accommodation, it's a township, Your Lordship. They have special quarters, proper security. It's a full-fledged township.
It's a gated township.
Yes,
of NIPCO.
gated proper security with every medical facility, everything is there inside.
Have you stated in your affidavit?
With regard to the availability of doctors, and yes, because this issue, security-wise, Your Lordship may just see para 18.
Para?
18, page 76 of my affidavit in opposition.
What is the para number?
18. Second page. Line 4, as regard to medical condition disclosed by the bidder, the same appears to be in any view of the matter, pare has
Para 18 appears to be a never-ending para.
No.
Para 16.
Small para.
Yes.
Page,
All right. Yes.
As regard the in any view of the matter, pare hydroelectric power station removed or has proper medical with petitioner can avail of.
All right, yes, anything?
My lord, my learned friend stated that SOP, the person who has been incumbent to her, he is from Delhi to Bokulani. They SOP to SOP stations, but she has been transferred to a hard station. Lordship, kindly see page 45 of transfer order. Santanu Bezwa DGM HR. He was here at New Delhi. He has been transferred to Bokulani. SOP to SOP. As per Insta, he has worked more than 13 years at Delhi. Now he has been transferred to Bokulani.
All right,
SOP to SOP.
anything else?
And DOPT circular and their transfer policy.
That you have already referred to.
And also another, when she was posted at AGPP, present place of posting, here one clause they have inserted. Since they transfer Srimati S.M. Goswami, person officer is based on at her own request, the period of posting AGP shall not counted toward eligibility of period of next promotion in terms of clause 21.4a of NEPCO promotion policy. But the Honorable Supreme Court here said on compassionate ground also, if somebody is posted, she or he can avail the promotion period on the counted by on that period. And she has already sacrificed her promotion.
This is not a prayer.
Promotion it is
Where is the order rejecting her representation? Page 55,
page 55.
53.
page 56.
You know, 54 are there. I do type it. Requires repair is not considered. Complies with headquarter order 54 is the original. And type to page. Non-speaking order, my lord, that online, one line order. And they have not considered any represented even so like also may hamper present service to school going children.
All right, that's all.
Yes.
Let me dictate the order. Heard Mr. A. Ahmed, learned counsel appearing for the raised petitioner. Also heard Mr. D. Senapati, learned counsel representing the respondent numbers 2 and 3. Who's any CGP appearing in this case for respondent number 1? None has appeared for the respondent number 1. Full stop. In this writ petition, the transfer order dated by filing this writ petition, the transfer order dated 15/1/2025, by means of which the writ petitioner was transferred from Assam Gas, the writ petitioner, who is presently working as Deputy General Manager (HR) under the Northeastern Electric Power Corporation Limited (NIPCO), and posted in the Assam Gas Based Power Station (AGBPS) (NEPCO) at Bokuluni, Dibrugarh, Assam, was transferred and posted at HOP, PHP, Doimuk, has been put under challenge. Full stop. The case of the writ petitioner, in a nutshell, is that she has been residing at Dibrugarh along with her husband, who is an employee of Oil India Limited, Duliajan, Dibrugarh, stop, bracket, another Government of India enterprise, bracket close, with her 2 minor daughters, one aged about 11 years and other about 6 years. Full stop. Both the daughters are studying in the Delhi Public School at Duliajan. Dibrugarh or Duliajan, residing at Duliajan. They are residing at Dibrugarh or Duliajan?
Julius.
Duliajan, not Dibrugarh, Duliajan. Full stop. Full stop. It is the case of the writ petitioner that she, along with her husband, are residing at Duliajan, which is only about a few kilometers away from Bokuloni, AGBPS NIPCO. Full stop. If the petitioner is posted at HOP PHPS Doimuk, then in that event, she will be compelled to part with her family consisting of two minor daughters who are both school-going students. Full stop. Apart from the above, the petitioner has also contended that she is suffering from severe diabetes and hypertension with breathing problem, and there is no proper medical facility at Doimuk, which may result into serious health hazard for her. Full stop. Full stop. On these twin grounds, the petitioner has approached this court, assailing the impending transfer order. Full stop. On 5/2/2025, this court had passed an interim order suspending the operation of the transfer order dated 15/1/2025, where the petition, the entire transfer order has been stayed.
Not
Where the petitioner. On receipt of notice in connection with the writ petition, the respondent numbers 2 and 3 have appeared and filed counter affidavit. The petitioner has also filed her rejoinder. Full stop. While arguing in favor of the grounds taken in the writ petition, Mr. Ahmed has invited the attention of this court to the office memorandum dated 12/6/1997 issued by the Government of India, Ministry of Personnel, Public Grievances and Pensions, bracket, Department of Personnel and Training, and is symbolic and bracket closed, to submit that it is the policy of the Government of India to provide same station posting to husband and wife so as to ensure that their family life is not disturbed. Full stop. Even as per the NIPCO transfer policy, submits Mr. Ahmed, namely clause 11.6, the request for same station or nearby place of posting of spouses is required to be considered sympathetically. However, despite these policy decisions of the Government of India, and notwithstanding the representation submitted by the writ petitioner to review the transfer order, the same has been rejected by the respondents by communication dated 24/1/2025 without however, assigning any reason for not doing so. Full stop. Mr. Ahmed has further submitted that As per clause 11.3 of the NIPCO transfer policy, diabetes and hypertension are treated as special diseases, and therefore the NIPCO medical attendance rules itself provides that employees suffering from such diseases ought to be deployed at a location of their choice or nearest to a location where facilities for treatment of special diseases are available. Notwithstanding the same, the respondents have rejected the request made by the petitioner, thus going against the policy decision of the institution itself. Full stop. On such grounds, Mr. Ahmed has prayed for setting aside, before that you write, it is also the submission of the petitioner's counsel that on earlier occasion, his client has in fact foregone promotion just to be with the family, since a promotion is associated with an order of transfer. Despite making such personal sacrifice, and notwithstanding the compelling grounds urged by the petitioner, the respondents have failed to consider her prayer in the light of the policy notified by the organization. As such, submits Mr. Ahmed, this is a fit case for the court to interfere with the impugn order of transfer. Full stop. Responding to the above, Mr. Senapati, learned counsel for the respondent numbers 2 and 3, submits that the petitioner has spent more than 16 years in the same place of posting, and it was done only to ensure that her family life is not disturbed. And it was done on the request of the petitioner with the objective of ensuring that her family life is not disturbed. However, at present, there is dire need of officers at the level of Deputy General Manager at the Doimuk, whatever that thing you write, PHPPS, so as to run the institution. And unless such a posting is effected, it will seriously affect the functioning of the institution. Mr. Senapati further submits that Doimuk is the nearest place of posting from Dibrugarh, and since there is a well-established township at Doimuk inside a gated colony, which not only has proper facilities of schooling for the children, but also adequate facility of healthcare, and medical treatment. There is no justifiable ground for the petitioner refuse to go to Doimuk. First up, referring to the policy decision of the Government of India, DOPT, dated dated 1 minute. Dated 12/6/1997, Mr. Senapati submits that the said circular is applicable in cases where the husband and wife are the employees of the same organization, and not in a case of this nature where both of them are serving in two different organizations. Moreover, according to Mr. Senapati, the guidelines of the DOPT are meant for government departments and not like companies such as NIPCO, which has its own set of rules, norms and guidelines for transfer and posting of the employees. First up, insofar as the plea regarding special diseases suffered by the petitioner is concerned, Mr. Senapati submits that those diseases have been classified as special diseases
only for the purpose of reimbursement of medical expenses, inasmuch as diabetes and hypertension are diseases which can be easily taken care of by the medical facilities available at Doimo. I have considered the submissions made at the bar and have also gone through the materials available on record. At the very outset, it is to be noted herein that the writ petitioner, the job of the writ petitioner is transferable in nature. Therefore, transfer from one place of posting to another would be an incident of service which the writ petitioner cannot refuse to comply with. There may be cases where, due to genuine hardship or difficulty faced by the person, a request for reconsidering the order of transfer may have to be sympathetically considered by the departmental authorities and suitably resolved depending on the options available at the hands of the authorities. However, the question herein is that, is it a case where the order of transfer issued to the petitioner deserves to be quashed by this court on the ground of hardship? It may be noted herein that it is not the case of the petitioner that the impugned transfer order contravenes the conditions of her service, or that the same has been issued with a mala fide intent to cause loss and injury to her. The grounds projected by the petitioner reduced to their essence amounts to a question of hardship and disturbance of family life. The stand of the respondent numbers 2 and 3 is that the petitioner has been allowed to continue in the same place of posting for 16 years so as not to disturb her family life. But at present, her services are required at Doimo for the institutional interest. Since there is nothing to dispute the said assertion of the department, this court is of the opinion that the writ court, in exercise of discretionary jurisdiction under Article 226 of the Constitution, cannot interfere with such transfer order merely on the ground of hardship, more so when there is no alternative available for the authorities to post the petitioner along with her husband, since he is employee of a different organization. It is no doubt correct that when there is scope and opportunity of posting the husband and wife together at one place of posting, regardless of any notified policy, every attempt should be made by a model employer to place the spouse in the same place or in the nearby places so as to ensure that the family life is not disturbed and the children do not suffer on account of the parents living separately in two different locations. However, the same cannot be an absolute rule prompting the court to interfere with every transfer order in every fact situation by ignoring the inconveniences and problems that may be faced by the department. If the administrative reasons cited by the department are found to be genuine, and if the court finds that there is no other alternative to, if the court finds that the decision, if the court finds that the transfer and posting
of the petitioner is reasonable in a given fact situation, then in that event, the reed court would be loath in interfering with such order of transfer, as the issue would have to be left solely at the discretion of the employer. Full stop. For the reasons stated herein above, this court is of the opinion that the present is not a fit case for the reed court to interfere with the into an order of transfer. Full stop. It would be for the reed petitioner to into an order of transfer. Consequently, the reed petition stands dismissed. The parties to bear their own cost. It cannot be an absolute rule for the court to interfere with each and every order of transfer, merely because it will create disturbance in family life. The line you put it in.
For hearing item 6.
Look, I've been told that the funds for the limb has been sanctioned.
Each has given it.
You're just here.
Funds for the limb has been sanctioned.
Yes, I've been told. Madam.
Mr. Gogo is there. Please come.
Yes.
But as fund has been approved.
Approved.
Ceiling has been given. Ceiling has been approved. Now the issue remains where to deposit the money. We won't be giving to the petitioner.
No. Question.
46 lakhs, 36,800.
Who is who is the nodal agency now to take it forward?
It was released to the PH department, Karbi Anglong.
No, we are concerned with fitting the limb on the petitioner.
Yes,
How is this to be done?
But that we have.
Hello, if I may suggest, my lords, there is already a medical board which is in place, my lords. So if the medical board endeavors to fit the limbs, my lords, the money can be paid through the medical board, my lords, or the Guwahati Medical College, my lords.
Private about this.
No, can you not suggest now that the money is there, how to implement it, how to fit the limb? Who's the right authority to do it?
My lord, they had submitted one estimate from a private agency which supplies the hand. And now perhaps they have to come which hospital they want. Otherwise, we'll be referring everything to GMC.
GMC will do it.
GMC, my lord.
Yes.
We'll find out GMC.
Let the GMC supervise let the GMC carry it out.
My lords, then perhaps the intervention of my lords, senior government advocate will be required, my lords.
There'll be other.
Let us see, money has come, let us put the limb and see if it works and if he gets a life.
But
This money is for the human life, quality of life, not for anything else.
And look, if it can be through the medical board, my lords, they can take care of the other paraphernalia also, like fitting and
It be
everything.
done under the supervision of the principal of Guwahati Medical College.
My lords.
Huh?
They have already been implemented, my lord. GMCH has been implemented.
Who is appearing for the GMC?
for the health,
Only appear GMC.
it is better not if the council health. I'll just yes, sir. Report is there. Okay, Mr. Nath, we'll just take up the matter after 10 minutes. Can you please point out the report and send for the medical standing council health? All right. Okay. Give me.
But if the doctor there, the member at that point. But no. If he is there, that is.
All right, then we'll ask the superintendent to supervise the fitting of the prosthetic limbs and all agencies to render necessary cooperation to him.
Yes, madam.
How much time will it take? 45 days? We will post it after 45 days.
This was the year ending is coming, my lord, the financial year. I hope there's no, well, because the funds may.
No, that is given. That ceiling is there.
Mr. Gogoi,
Hey,
you are aware of this matter?
hey, Lord of Hachi.
Also sanction already. Sanction limbs of.
So now the money has been sanctioned, the fund, the prosthetic limb, electric limb has been identified. The idea is to see that this boy can be given a life which is near normal life. Otherwise, both hands out from here. And the days ahead when his parents are no more will be terrible for him. So the medical board says it is possible, but it's expensive. So working on some orders of the court and their no, these are medical issues. We'll ask this superintendent. Huh? Or you want we can take it up next week if you want to find out next Wednesday.
What sort of assistance will require?
So then why don't you work out how you want to do it? We'll have it on next Wednesday. Heard Mr. P. Das counsel appearing for the writ petition, also heard Mr. D. Gogoi, learned standing counsel for the PH department Assam, who has handed over copy of the notification dated 18/3/2025 issued by the Special Chief Secretary to the Government of Assam Public Health Department dispute to submit that a sum of rupees 46 lakhs 36,800 has been sanctioned by the government and a ceiling has been issued for the purpose of fitting the prosthetic limb on the petitioner. Full stop. With the above development, the financial requirements for fitting the prosthetic limb has been taken care of. The question that would now arise is to the authority who should be entrusted with the responsibility of overseeing that the prosthetic limb in question is properly fitted to the petitioner without any further delay. Mr. B. Gogoi, Mr. D. Nath, learned Senior Government Advocate Assam, Mr. B. Gogoi, learned Standing Counsel for the Health Department, and Mr. R. Rohang, learned Standing Counsel for KAC, have prayed for posting this matter again on, we'll have it on 3rd April 2025, so as to enable them to examine the issue through a consultative process and appraise this court as to the suitable mechanism that can be followed in this case. Prayer allowed, list this case again on 3rd April.
So the report, I'll take it.
Take back the report. Yes, why this case is
May I-
not covered?
On the last occasion, Lordship has posed a pointed query, my lord. I am obliged to that. And
Yes.
Lordship has posed two pointed queries. Number one, my lord, to distinguish whether, my lord, that decision covers the present case or not, number one. And number two, whether there is any deduction. If there is any deduction, my lord, that means he have waived his right. He have submitted to the, my lord, for, my lord, deducting that NPS. So he is, my lord, satisfied with it. Now he cannot revert back. The principles of waiver estoppel will operate against him. To that extent, my lord, I have received the instructions. They have supplied, my lord, the pay slips and related documents, my lord, for the month of November 2014. And the petitioner, he was regularized in the year, my lord, 2008, and subsequently he came to be retired in the month of January 2015. In that bunch of paper, if lordship comes to page number 3, my lord.
Yes.
Page number 3, my lord, there are two tables down below, lordship will find. On the right hand side, I have put a red tick mark, my lord. There, lordship will find deductions. In the first row, lordship will find General Provident Fund subscription, then NPS. NPS. This is the deduction.
So only one.
This is for instance, my lord. They have provided us for instance, my lord, for the month of November.
So NPS amount has been deducted
Yes.
from his salary.
Yes, NPS is deducted from the salary. It is put to a defined, my lord, account.
And
It
the
is put-
government employer has put its contribution to that.
Yes,
So
employees.
this means this amount of 13,600,
Yes,
same amount has to be deposited by the government also.
yes, same amount.
It has been done.
It's been done. This is the pay slip and these are the records, my lord. All the monetary records are there.
My lord, in the meantime, clarifying everything, I have filed an additional affidavit. That is not the issue. What is my learned friend is submitting? Number of litigations.
First, this is the issue. We'll go to something else later on. Was any money deducted from your salary in the NPS?
In case of Hussain Ali's case, also money was deducted. In the covered case, which we
So
are relying.
where is it mentioned in the judgment that money was deducted?
That may not be any mention, but
These things will not work. Don't
lordship,
even try all these things in this court. We will go by the law.
question
If
is
that aspect is not considered in that judgment, that will have nothing to do in your case.
that is the question is whether my part service, commission basis service is to be counted.
Nothing, you file an affidavit, we'll close it. Your question will not help. Take down. In terms of the order dated 13/3/2025, Mr. R. Borpujari, known as Standing Counsel for the Finance Department, has obtained instruction and has produced documentary evidence to show that
My lord, my learned colleague, my lord, he is appealing for the revenue. Lordship may kindly record his name. It has come from revenue.
Provident Fund contribution under the NPS was deducted from the rate petitioner's salary from time to time with matching contribution from the employer, and therefore it is a clear case where the petitioner himself had agreed to, himself had submitted to the NPS. Full stop. Under the circumstances, the question of now claiming benefits under the old pension scheme cannot arise under the rules. Full stop. Mr. Borpujari prays for 3 weeks' time to file an affidavit bringing the said facts on record, thus giving an opportunity to the rate petitioner to rebut the same. Full stop. Uporot Dibo, Mr. R. Islam, learned counsel for the petitioner. Mr. R. Borpujari, learned standing counsel finance. Mr. S. Datta, learned standing counsel for revenue department. Mr. T. C. Chutia, learned. You are for respond number?
I am for respondent.
Can you give the names who can't respond on the?
Lordship, may kindly be pleased to record my colleague's name
Yes,
because
yes.
the instruction has come from him. He will file an affidavit, my lord, not me.
Acha. Then instead of R. Bharpujari, right?
In my place, my S. Doctor, my lord.
Who is for whom? Can you tell? Who is for one?
I'm for 1 and 4.
1 and 4.
1 and 4. I am for 2, my lord. I am for 2.
1 and 4.
1
2,
and 4. I am for
Mr.
2, my
T.C.
lord.
Chutia, 3 and Mr. B. Chakravarti for respondent number 6. The instruction has been produced by Mr. S. Datta. Mr. Datta, however, prays for 3 weeks' time to file an additional affidavit bringing the complete facts on record with supporting document. Since the above issue would have a crucial bearing in the outcome of the writ petition, this court, although this is an old pending matter of the year 2015, this court is left with no other option but to permit the learned departmental counsel to file an additional affidavit by serving advance copy upon the petitioner.
I may be allowed to file
Yes.
reply.
The petitioner's counsel would be granted 3 weeks time, 3 weeks further time to obtain instruction and file rejoinder. Let the matter be listed again after 8 weeks, but this writ petition shall not be treated as part heard before this court any further.
I'm so.
Lordship.
But in the meantime, my lord, the finance department may also file an affidavit. We have not filed, my lord.
The Finance Department of Government of Assam may also file affidavit in the meantime if so advised.
I'm so grateful, my lord.
See, the correct thing has to come out.
Yes, Lordship.
If he has submitted to NPS, then you can't.
No,
get-
in case of Hussain Ali also, he has also contributed.
Then
but
that's
not
I
taken.
don't know. That is up to them to prefer.
I have not taken it back because I filed representation before that.
That we can't comment.
In
That judgment is-
writ petition.
that is by division bench. That is over. But I will go by what is the correct law.
Lordship is absolutely.
You are lucky. Keep quiet. Otherwise, they will prefer. an
Regarding applicability of NPS, single bench and division bench both debated. But I have not taken it back. Because the moment Hussain Ali's judgment was passed on 22/9/2014, I filed representation that I am not taking.
Others they will file appeal and take away. That one also.
For going for SLP now, the time is over.
You keep quiet. Yes, yes.
Deeply obliged. My learned friend said, his affidavit is ready.
Affidavit is ready, my lord. I sent to the, my lord, Transformation and Development Department. They says no, my director of country planning is there. Again, I sent it, my lord, on 7 March. To sign the affidavit. my lord.
This is the old matter of 2000.
All matter, but I will clear it, my lord, within next week, my lord, I will clear. Over telephone, my lord, I will take it. I have sent it, my lord. And soft copy also I have sent it on 4/3/2025.
Can it be then fixed on 11th, my lord?
Oh, 11th, yeah.
Tuesday, let him file. I
Yes, yes,
also want, my lord.
11th.
11th of March.
11th of March is gone.
April, I'm sorry, my lord. 11th of April, that is Tuesday. Because I also want, my lord, an affidavit to come because.
So what is the matter about?
My lord, the petitioners are all employees of the various development authorities.
Hmm.
They have not been paid, my lord, salaries for months together, my lord, because of fund crunch. The government earlier said they also have some problem, financial problem, they couldn't provide from. Now, there is no problem for them.
They are employees of which department?
My lord, all development authorities, my lord, various. Because of the, my lord, amendment of the Municipal Act, bringing the areas of development to the municipality, my lord, there is no revenue grant, there is some revenue grant of the development of the. Therefore, my lord, the government used to provide fund, not the other authority, but not to the development authority.
On the request of Mr. T.C. Chutia, learned additional senior government advocate Assam representing the state, 10 days further time is granted as last chance for the department to file affidavit, failing which the right of the respondents to file affidavit shall stand struck off.
Right.
Let this matter be listed again after 2 weeks as a fixed item.
Lordship.
Number 8.
Huh?
Impelling for respondent number 8.
Acha, Mr. So-and-so, Mr. Mishra is present on behalf of respondent number 8.
Deeply.
R.S. Mishra.
Hello.
Last item.
May please, your lordship, I'm praying for a possible extent.
On the prayer of petitioner's counsel, this matter stands possible for the day.